Police departments rarely change their policies because they get stuck in their ways over many years, and it's a pain in the butt to retrain everyone on those new policies. But a recent case of ours changed roadblock procedures in one little Virginia hamlet. Here's an actual case of ours that made a significant impact not only for our client, but for other people who might come through one of these roadblocks. Ladies and gentlemen, the story you're about to hear is true. Only the names have been changed to protect the innocent. And we had to edit hours of court testimony to make for a decent YouTube video. It all starts with my client Joe being stopped at a DUI checkpoint. A police dragnet, if you will. We're conducting a DUI sobriety checking detail. May I see your license and registration, please? And where are you coming from tonight, sir? Didn't you hear me, son? I detect the odor of an alcoholic beverage emanating from your breath. Pull over to the side with me, son. Yes, sir. Joe is arrested for DUI, and he realized he has a lot on the line. If he's convicted, he will lose his job and not be able to provide for his family. Joe hires me and my law partner, Ryan Fitzgerald, to defend him, and we start crafting his defense. Lo and behold, we find a silver bullet. The officer did not sign the breath testing certificate. To be used as evidence in court, Virginia law requires the breath test operator to attest to the results of the breath test on the face of the certificate. Since Joe's officer did not actually sign the form attesting that he did everything properly, the breath test should not be able to be used in evidence against Joe. So without the breath test certificate, the Commonwealth has essentially no clear evidence to show that Joe was drunk. And if Joe wasn't drunk, he can't be convicted of driving while under the influence. We think we have a great case here, and I show up to court in a great mood, ready to fight. Joe and I start the trial by pleading not guilty. Since the prosecution always gets to go first because they have to establish a prima facie case against the client, Officer Andy takes the stand.
Is this a copy of the checkpoint plan?
Yes, sir.
And did you follow it as the plan specifies?
Well, to some extent. Sometimes we got busy and we couldn't check every single car.
You didn't stop all the cars?
Well, we checked every car that we stopped. Hold on. The prosecutor pokes a major hole in his own case. Police roadblocks are a Fourth Amendment violation waiting to happen. These roadblocks or checkpoints are only constitutional if they meet very specific criteria. And one of those criteria is that there has to be a written plan and the police have to follow their own plan. I had reviewed the actual plan for this case during discovery, so I know that it says in black and white that all cars are to be checked. And by admitting that they didn't check all the cars in this case, Officer Andy has just essentially proven that the roadblock is unconstitutional as executed in Joe's case. And I pounce. Your written plan says you're supposed to check all the vehicles at the roadblock? Yes. And yet you didn't check all the vehicles because you got busy. Yes, sir. That's correct. Your Honor, I move to suppress the stop. By not following their own rules, the Commonwealth has just shown that this roadblock was a violation of my client's Fourth Amendment rights. Unfortunately, the judge rules against me. He says that since the officers didn't affirmatively wave clients through the roadblock, that means that they did in fact check every car that they stopped, and therefore he allows the roadblock to proceed. But I don't get upset because I still have my silver bullet loaded and ready to go. The prosecution tries to offer the breath certificate into evidence, and I object. The judge reviews the certificate and agrees with me. My silver bullet hits the bullseye, and now there is no clear evidence to show that Joe was actually intoxicated in this case. But then the prosecutor pivots and asks,
Did you give him a breath test?
Yes, sir.
And what was the result on the machine screen?
Objection, Your Honor. The officer can't testify to the reading since the breath test procedures weren't followed. But the judge overrules my objection and lets Officer Andy answer. The machine showed a .09. Even over my argument that the government has not proven intoxication, Joe is convicted of DWI, and now his job is in jeopardy. We appeal the case, and we have time to think about what we're going to do next. On a long flight to visit family back in Texas, I spend the entire time researching and reading just about every Virginia roadblock case I can find. And I am absolutely convinced that the trial judge made the wrong decision given these facts. So I began drafting a 10-page motion to suppress the roadblock to use in our appeal. Thankfully, with our appeal, we're getting a do-over. In most states, if you appeal the case, you don't argue the same case in the same room with the same judge. You get to go to a different court to argue with a different judge. That's the way Virginia works. You have one trial in the General District Court where Joe lost the first time. And then if you appeal, you get what's called a de novo right to appeal. So you get a complete do-over in the circuit court. Eventually, if you keep appealing, this is how some cases make it all the way to the Supreme Court. I'm also excited about our chances of winning in the circuit court due to this legal issue. And because I think that some judges in the General District Court are a little bit quick to convict, because they know that if they dismiss the case is over, and the Commonwealth can't appeal that decision. However, if they convict the wrong person, that person can still appeal and can still have another judge review the decision in the circuit court. So you do get that do-over, and I think that does incline some judges to be a little quick to convict when maybe there is reasonable doubt in some cases. But just in case I'm wrong or Fitz and I have missed something, I use the Freedom of Information Act to request the police department's standing orders about how they're supposed to conduct roadblocks in general. Sure enough, those orders require checking every vehicle as well. Several times it states that there's not to be any discretion used in the roadblock and that all vehicles are to be checked. We show up on time in the circuit court, ready to fight our motion to suppress, and Officer Andy is a no-show. Joe is ecstatic and turns to me asking, "This means we win if the cop doesn't show up, right?" Sorry, Joe, that's a myth. We just have to come back and fight another day. We show up again the next week, and Officer Andy does show up this time. The Commonwealth puts on all their evidence again, and the judge says he's actually taken the time to read my 10-page motion to suppress. Based on the admission from the police that they did not screen all the cars in this roadblock, the judge agrees with me and rules the roadblock unconstitutional. Case dismissed. We win, and Joe keeps his job. And I'm told the police have already amended their roadblock plan to try to plug this defense argument in the future. Sadly, that probably means they're going to conduct roadblocks in the exact same actual manner, but they've added some language into the plan probably that gives them a little bit of discretion to stop checking vehicles if they get too busy. To see exactly what you should do at a DUI roadblock to defend yourself, check out this next video. And remember, don't talk to the police, even at a roadblock.